So let's look at now voting in the meeting. So voting, as I said, is essentially going to be either by a show of hands, one person, one vote, or on a poll that is voting essentially according to the number of shares held and the class of shares. When we're voting, the proposal for the item will be extremely important. This is something that is perhaps not terribly intuitive, but for example, in US law, it is very difficult for members to make certain kinds of proposals. And so in this way, it's very difficult for the members to get these kinds of things done. And the directors tend to control it, for example, nominating candidates to the board. So the board has control over who is nominated, which means that it's very difficult for the members to get people into the board that the board itself does not like. That's not the case in Hong Kong. So we have directors normally proposing, but we also have the possibility of a relatively small threshold, a low threshold. 2.5 of the vote or 50 members may request a proposal be made for the meeting. And then normally only retiring directors are eligible for re-election, but a member may also propose a nominee. And that is quite a power. So written resolutions are something that we have not discussed yet. And written resolutions are essentially the email copy to all. So we send an email to everyone on the list, and we ask everyone on the list to decide on whether the proposal in the email is correct and acceptable. And the significant difference with written resolutions is they must be approved unanimously. So you can see how the written resolution tool for a larger company with a great number of members is not going to be used a lot, because a single member may prevent the resolution from being adopted. We leave the written resolution out in circulation for 28 days, and if not approved by that time, the resolution will not go through. And directors will normally propose the written resolution, but also at 5% of a threshold, members may do the same. So who can vote? That will be the members who are registered as members at the time that the invitation is sent out. And this means that if you were to sell your shares after the call to meeting has been sent out, you would still be able to be eligible to vote in the meeting, but the owner of the shares would not. And so we can sell shares with a contractual promise, essentially a proxy, to the new member who will not be invited to the meeting. And so the outgoing member would simply give the new member a proxy, and they would vote on behalf of the member who was on the list of members when the invitation was sent out. And this happens because the register is closed. You can see how for the company it would be very messy if the company had to meet the 21-day requirement for giving notice, and then shares were sold and new members were entered into the register of members, and the new notice needed to go out with 21 days notice, so you would have the date of the meeting receding into the future. And for that reason, when just before the notice to meeting goes out, the register will be closed, no changes will be made until the meeting, and that list will be used for those persons invited to the meeting, and the same list will be used for paying dividends. And so again, a contract may be made to transfer dividends to the new buyer of the shares. If you're trading on the stock exchange, your shares may be registered in the name of the Central Clearing and Settlement Service, CCAS, and so CCAS would be the real member of the company, and CCAS would have to arrange to give you a proxy to vote if you wanted to vote. For an unlisted company with partially paid shares, it may be possible to call more payment on the shares. If those payments are not made, then it is possible to forfeit the votes and also dividends on those shares. Classes of shares will always determine the voting rights. So, as I said, votes are going to be cast by a show of hand or in a poll, right? So show of hand is every member, one vote. And a poll will be according to the shares owned, and that will be specified in the class of shares how many votes or whether it's even one vote per share. Okay? The chair must demand a poll at the meeting if proxies received show that the show of hands would result in a different decision than the poll. And the right to use a proxy is a very important right because that allows members who have to work, for example, or will not be in Hong Kong when the meeting is held, to exercise their rights in the shares. This is very important for investor protection. So remember the required majorities for the resolution. Remember, when we're talking about a percentage, we're always talking about some number over 100. But the denominator of the fraction, the actual denominator of the fraction, will vary depending on whether the percentage is of total voting rights, total share capital, or the number of votes actually present at a meeting in person or in proxy and cast. Okay? So we're looking at a simple majority for an ordinary resolution of votes present and cast, or 75% for a special resolution of votes present and cast. Right? And then we have these appeal votes with regard to alteration of class rights or alteration of the object of the company. Those use a denominator of all votes in the particular group. Cumulative voting is something we haven't talked about at all, and you will not be tested on cumulative voting. It is not provided for in Hong Kong law, but you may see the term, and I think it's useful just to explain how this works. So here we have a voter, and we have a board. Assume this board of 4 persons is retiring and up for vote. The voter has 25 shares, 25 votes. Now, this member may cast, or in an ordinary sense, 25 votes for each person on the ballot. So if another member has 26 votes, then this member will not be able to appoint any of the directors. The person with 26 votes will be able to outvote this 25-vote member for every single board seat. And so this 25-vote member, even though only 1 vote less than the other member, will receive 0 directors, and the member with 26 votes will receive all 4 directors. However, if we introduce cumulative voting, what we allow this minority member to do is take all of their votes, 25, 25, 25, for the 4 directors, combine them, and focus them on a single, or let's say 2 directors. So if that were done, then the member would be able to elect 1 chair, because let's say the 26 vote member is focusing on all of the board, and so for this one particular chair, we would have 100 votes versus 26 votes, and the minority member would be able to appoint one person to the board. That can be provided for in the Articles of Association of a Hong Kong company limited by shares, but it is not currently provided for in either the model articles or the company's ordinance. Proxy is essentially a contract, as I've explained, and so we have a contract that sends a human being to the meeting, or we have a written instruction which is sent to the meeting. Right? It must be in writing, and then at the cutoff date, the members who are in the register of members will then have the power to grant a proxy to other persons, including persons who buy their shares after that date. So here's a small cartoon. We have a member of a company. The company is holding its annual meeting. The member decides to send his lawyer to the meeting as a proxy. He gives the proxy to the lawyer. The lawyer then goes to the meeting and submits the vote. Right? And this would be the member appointing a human being as his proxy, but the member could also simply mail in or send an electronic instruction, and that would be called a proxy as well. Directors may not use company funds to volunteer proxies to only some members. This is a specific provision which stops a trick that directors may use, which would be to take the company funds and campaign for themselves and for their friends, looking toward the specific members who want to support them. And this is not possible under Hong Kong company law. Remember that we have class meetings as well. So if there were to be a general vote to, let's say, amend the articles in order to change the rights in a class of preferred shares, then it would be necessary that those preferred shares have their own meeting, and they will be asked whether they consent to this alteration of their rights. Right? So the rules for meetings that we've just discussed will apply with applicable changes to the subgroup of members that constitute the class. Right? And of course, there will be no annual class meetings, although that could be provided for in the class itself if that's seen as attractive. But generally speaking, there will be no annual class meetings, and class meetings are called by the directors or with permission of the court. Okay? And then meetings changing class rights have an initial quorum of 2 members representing 1/3 of all class votes, and the right to demand a poll is absolute. And so class meetings will generally be in an occasion where there has been a meeting by the company to alter the rights of the class, and the class is asked to consent to this. So next week we'll supplement this view of the meetings of the members with a study of the information, aside from the simple call to meeting, that the directors must prepare and give to the members before the meeting in order to allow them to decide whether they, for example, want to reappoint the directors for another term on the board.